Uber classified drivers as independent, then controlled every minute of their shift. In a 2024 federal lawsuit, plaintiffs' attorneys submitted internal Uber communications showing that executives discussed the legal risks of driver classification years before the first lawsuit was filed. Those communications have not been made public. What they contain, and why they haven't surfaced, is the thread this entire case pulls on. The pitch was freedom. Drive when you want. Stop when you want. No boss, no schedule, no ceiling on what you earn. Uber didn't sell drivers a job. They sold them autonomy, and millions bought it. By 2023, Uber had 5.4 million active drivers globally. Most had signed on believing the independent contractor model meant exactly what it said. It didn't. Independent contractors set their own terms. Uber sets the fare. Uber sets the route. Uber decides, algorithmically, who gets rides and who sits idle. You can't negotiate the price. You can't choose the job. You just accept or disappear from the queue. That's not a contractor. That's a managed worker with no employment protections. The lawsuit, filed in California federal court in early 2024, doesn't just allege misclassification. It alleges a system. Plaintiffs argue Uber uses a combination of dynamic pricing, acceptance rate monitoring, and algorithmic dispatch to enforce compliance without issuing a single direct order. No manager, no memo, just the math, designed to extract obedience while maintaining legal distance. Acceptance rate is the mechanism worth understanding. Uber has repeatedly claimed drivers face no penalty for declining rides. But the lawsuit cites driver accounts and Uber's own app behavior, showing that drivers who decline too often get fewer high-value ride offers, lose access to surge pricing windows, and in some markets, receive account warnings. Uber never formally calls it punishment. The effect is identical. In 2016, a Princeton economist named Alan Kruger co-authored a study with Uber. The paper concluded that driver flexibility was real and driver satisfaction was high. Uber cited it for years. What they didn't advertise, Uber supplied the data. Uber reviewed the methodology. Kruger later said he had limited ability to verify the underlying figures. The study that proved independence was built on numbers only Uber could see. This isn't the first lawsuit, it's not the 10th. In 2020, California passed Proposition 22, ballot language that would exempt gig companies from classifying drivers as employees. Uber, Lyft, DoorDash, and Instacart spent $224 million campaigning for it, the largest ballot measure expenditure in California history at the time. They won. In 2021, a California Superior Court judge ruled Prop 22 unconstitutional. That ruling was later partially reversed on appeal. The law is still unsettled. The strategy was not. A driver named Victor Vasquez testified in 2022 that he worked 70-hour weeks on the Uber platform and earned less than minimum wage after expenses. Gas, insurance, vehicle depreciation were factored in. He received no sick pay when he contracted COVID. No workers' compensation when he was in a minor collision. His flexibility was the flexibility to absorb every cost Uber wouldn't. Here's the number Uber doesn't put in the press release. A 2022 Economic Policy Institute analysis found that, after accounting for vehicle costs, the effective hourly wage for U.S. rideshare drivers was approximately $921 per hour, below federal minimum wage in real terms. The app said, "Be your own boss." The math said, "Work for less than McDonald's pays." Uber's revenue that same year, $31.8 billion. In 2017, internal Uber documents obtained during separate litigation revealed that the company had specifically modeled the cost of reclassifying drivers as employees. The number was $500 million annually, in the U.S. alone. The documents showed it wasn't a legal question. It was a line item. Classification wasn't a gray area they were navigating. It was a cost they had already priced. Former Uber CEO Travis Kalanick was explicit in internal communications about the importance of the contractor model, not because of flexibility for drivers, but because full employment classification would, in his words, fundamentally alter the unit economics of the business. The business model didn't produce contractor status as a side effect. Contractor status was the business model. Uber's public position has always been that drivers prefer independence. That surveys show most don't want to be employees. In 2021, Uber commissioned one such survey. It found 73% of drivers preferred flexible work over employee status. What the survey didn't ask, whether drivers wanted employee benefits alongside flexibility. When the UK Supreme Court asked that question, implicitly through litigation, it ruled unanimously in February 2021 that Uber drivers were workers entitled to minimum wage, holiday pay, and pension contributions. Uber's response in the UK, compliance. Uber's response in the US, lobbying. The 2024 lawsuit introduces a specific new claim. It alleges that Uber's deactivation system, the process by which drivers are removed from the platform, violates due process protections that should apply to any de facto employment relationship. Drivers can be deactivated by algorithm. No hearing, no appeal with teeth, no severance. One complaint from a passenger can end a driver's income. Uber doesn't have to prove it happened. The driver has to prove it didn't. The burden of proof runs in one direction only. Court filings in the 2024 case reference an internal Uber category called reliability score, a composite metric drivers are never shown directly, but which allegedly governs ride allocation, surge access, and deactivation risk. Drivers are managed by a number they cannot see. That's not a side effect of automation. That's a design decision. The stakes in this lawsuit extend beyond Uber. If the court accepts the plaintiff's argument that algorithmic control constitutes the functional equivalent of employment, it would expose the entire gig economy to reclassification liability. DoorDash, Lyft, Instacart, TaskRabbit. Every company that built its margin on the contractor gap is watching this case. Uber became profitable on a GAAP basis for the first time in Q3 2023. The announcement was celebrated as a milestone, a proof of concept, a vindication of the model. What the earnings call didn't frame it as the moment Uber confirmed that profitability required the labor costs it had spent a decade litigating its way out of paying. They didn't build a profitable company. They built a profitable structure. The drivers are still out there. Tonight, routing through the same algorithm. The lawsuit is live. The classification is unchanged. Uber didn't accidentally misclassify 5 million people. It built a system where misclassification was the foundation. The app still says, be your own boss. The filings say something else. The business model was never the technology. It was the legal gap, and they knew exactly how wide it was. This is Redacted Chapter. Subscribe so you don't miss the next one.